Hello, everyone. Sufit here. I'm here today with Charles Ticker, estate mediator and author of the popular book, Bobby Gets Bupkis. Charles is joining us today from siblingestatedisputes.com. Welcome, Charles.
Thanks, Sophie. Good to be here.
So I saw this article online. I think it was on Yahoo Finance. Vaughn, Vawn Himmelsbach, little post about a story, a sister who says, I took care of mom, and so my other sibling doesn't deserve half the inheritance because she moved away. So I guess the one who moved away is asking the question, and the one who moved away has two kids, full-time job, lives across the country. So the one who moved away is asking the question, can I keep the inheritance, but still keep the peace with my sister? Like, is that a possibility? Um, uh, and this Vaughan Himmelsbach suggests that this could have and should have been figured out while the person was alive. Is this a common scenario?
It's a very common scenario that I see in my mediation practice and formally in my estate litigation practice, where uh, the sibling who did the lion's share at the caregiving for an elderly parent is expecting to be rewarded for that, or expecting to get more of the estate. You would argue, well, what could be more fair than just splitting the estate, equally amongst the siblings? Well, the sibling that's done the lion's share of the caregiving and maybe made sacrifices and maybe even was promised to get something more is not going to be satisfied in a lot of cases with just being getting half. So how's that person going to keep the peace? Well, it could be a challenge if they decide that they don't want to give anything back to the sister uh, who did the lion's share of the caregiving, and we see a lot of those cases in our courts, and like I said, in my mediation practice.
Now that you mention it, I don't remember if it was chapter 3 or 4 of your book, but I think one of those chapters is about equal, not fair, and the other one's about unequal, not fair. So I
That's
guess
right.
this would be an example of equal, not fair, yes?
Equal, not fair, because everyone. Yes, I'm sorry. Go ahead.
At least in the from the point of view of this sister who did the caregiving.
Yes, I mean, I think what I wrote in the book is that equal, is not necessarily equitable. And I guess the sister who did the caregiving, uh, while the other sister, moved away, and she may have had very valid reasons for being away, and had nothing to do with her not loving her mom or being a good daughter. People move away. But the sister who did the lion's share of the caregiving, doesn't feel it's fair, right? So that's why they end up in a dispute.
Interesting. So if these people were in your mediation room, um, and with the stated goal of keeping the peace, how would you go about this? Like, is this a scenario where really the sister who did the lion's share of the caregiving really just needs to be heard? Do you think is that a possibility, or does the sister really need more money in order to walk out feeling that it's fair?
Well, it's hard to say, every case turns on its own facts, but the sister who did the lion's share of the caregiving, depending on the circumstances, may very well have legal grounds for bringing a claim against the estate. It's not just a question of uh, being heard. They may actually have a right to go to court and succeed in a claim. So there is exposure there. Um, to the sister who moved away, that she may at some point be ordered to give up some of her inheritance, or maybe all of it, to the sister who did the lion's share. So there is a risk there. On the other hand, there's a risk to the sister who wants more, that she may not succeed, or that she's going to spend more on lawyers' fees than it's worth. And that's basically what I try to do in the mediation. I mean, I can't predict what a judge is going to do. Nobody can. But it's that uncertainty that uh, motivates the parties to settle, because a settlement's a sure thing. Going to court is not a sure thing, and it's a very expensive exercise.
That's a really good point. A settlement's a sure thing. The mediation would end the limbo, I guess, the uncertainty.
Right.
Is the situation where the where the sister did have a valid claim, would that be based on some expectation that the parent sort of led the person to believe there would be more, or just the fact of doing the work itself? Like, is caregiving in and of itself giving you the right, or is it that the testator kind of led you to believe? What's the relevant question there?
Well, it could be both. I mean, you have a situation where the testator, that is the person making the will, the parent has made some sort of promise, saying that if you come in and look after me, and I've seen people give up their employment, move in with mom or dad to look after them. I'll make sure that you're looked after in the will, and that doesn't happen. So there's that broken promise. But aside from that, there's the situation that the person who's doing the caregiving, have they suffered some sort of detriment? I mean, obviously if it's they've benefited, the parent has gotten some benefit, hopefully, from the caregiving. And if the parent hasn't paid for those services, has the child made a sacrifice? And has there been some detriment? So the courts will look at that detrimental reliance, and they'll see, is there any reason why the person would do it, for nothing or for little money. So is there what they call a juristic reason for it? But so in these situations, which come up all the time, uh, you'll get the caregiving child saying, "Look, I've made these sacrifices and I benefited the parent, and I should be compensated." And then you'll have the other siblings say, "Well, that's great, but you got free room and board, and that was worth something. So what are you complaining about?" Uh, so
Yeah.
it really depends on the family dynamic, and I think in these disputes, well, there may be a legitimate dispute there. It's going to be more difficult to settle the dispute where there's been a history of disagreement between the siblings. The scenario you described to me suggests that maybe they had a good rapport, um, and this is a more recent development. So that might have a better chance. But all these cases, mediation is still, I believe, the way to go. Is a high rate success in these kinds of disputes and settling these disputes.
Okay, there you have it. Mediation is the way to go. At least it will be resolved in a way that hopefully both parties can live with. Our guest today has been Charles Ticker, estate mediator and author of Bobby Gets Bubkus. Charles joined us today from sibling estate disputes.com. Charles, thank you very much.
My pleasure.